And I really felt that the family court was a place that should be open to the press.
Yes.
Because at that time in New York, and probably in a lot of other places, it was sort of the dumping ground for morons and political hacks.
Okay, so what else is there?
You have to put them in a place where nobody can see the morons that we're pointing to the court. Now,
And then, so she went down and tried to register the foreign decree, which violates my civil rights to an appeal, which you won't acknowledge for whatever reason. Then, subsequent to that, she went down to the child support office and tried to do the same trick. So again, she's harassing me. Would you like to see these documents to verify that these actions took place?
Mr. Greenberg.
Would you like to see these documents to verify that these actions took place?
Mr. Greenberg, we're here with respect to a request to renew a restraining order that currently protects Ms.
Right, and I also need to be protected from her. She can't hide behind a protective order to harass me. But
Well, that's not before the court. So if you wish to, intimidation happens to be a basis for abuse under the Family Code section 6320. Intimidation happens to be a basis for abuse under the Family Code section 6320. Apparently filed your own restraining order request in Tennessee. Everything you're presenting right now can be taken care of in Tennessee.
okay.
Going on in Orange County. That is not before me. It is before Judge Robinson, but it's not before me because I'm here just to hear the petition for the order of protection.
Okay, can you see my screen okay?
I can. And it's the definition essentially of domestic violence.
Yeah, so we're going to walk through that and then some other
Well, we
items.
don't have to walk through that. I know what domestic violence is.
Intimidation happens to be a basis for abuse under the Family Code section 6320.
It's what I do. This is what I do. I hear nothing but domestic violence cases, so I don't need the definition of it. I know what I need to know about that. I need to know what she did that constitutes domestic violence. What
Right.
actions?
And we're getting to that.
Go ahead, please.
Okay, so under Rule 3, I have the appeal as of a right. You can see that here, right? In civil actions, I'm sorry?
I see that.
Okay, so in civil actions, every final judgment entered by a trial court from which an appeal lies to the Supreme Court or Court of Appeals, an appellant is as of right. Meaning, I have the right to appeal my case in California. Are we all in agreement of that?
I have nothing to do with your case in California. I know what an appeal is, sir. I'm an attorney and I'm a special master, so I know what an appeal is. Again, I don't have anything to do with that. And no, we cannot agree that there's anything going on in California that I can take judicial notice of because I'm not familiar with it. I will assume, though, for purposes of this hearing, that you are correct in that.
Okay, well that's the actual violation of my civil rights. So we have to verify or validate my claim. You have to be able to do that.
A civil rights violation of a statute is not a ground for an order of protection. Now,
Intimidation happens to be a basis for abuse under the Family Code section 6320.
I'm not saying that there was not a violation of some kind of Rule 3 or of your rights, but that's not what an order of protection is for. An order of protection is to protect you from physical harm or threats of such intimidation and harassment and stalking that it rises to the level of stalking in Tennessee. That's what an order of protection is. This is for physical domestic abuse.
No, so
my question to you is what she did. How did she physically abuse you or threaten you?
right. So physical abuse also includes physical violence, sexual violence, threats, and emotional abuse. It doesn't have to be physical. We understand that, right?
I'm going to tell you again, sir, I understand what domestic violence is. So you can skip the definitions of the domestic violence as of now. You want to argue that in a minute, that's fine. I've not heard one allegation yet of what she did that was sexual, physical, emotional abuse. That's
Right. Okay. So now we've included emotional abuse. That's very key. So now further, it says I have the right to appeal. Okay. Now what do I need to show you that will validate my claim that this case is on appeal in the state of California?
Would you please explain to me why that's relevant?
It's relevant because if she's trying to intimidate me or infringe upon my right to pursue that appeal, that is emotional abuse.
Okay, well, not all emotional abuse is protected under an order of protection statute. It has to rise to a certain level. I mean, there's verbal abuse and there's emotional abuse, and the court can't protect you from just any verbal or emotional abuse. It has to rise to a certain level.
Right, a statutory level defined by the state. That's right.
Right now, you're just saying her attempt to fraudulently register a final decree, which is not final, you said it's on appeal, is abuse. and it's the abuse that you are putting in the forefront of your allegations. Is that right?
Yes, so under Tennessee Title 39, Criminal Offenses, Chapter 17, Offenses Against Public Health, Safety, and Welfare, Part 3, Disorderly Conduct in Riots, 39-17-309, Civil Rights Intimidation. We agree that exists, correct?
I don't answer the questions, you do.
Okay, so anyways, the General Assembly finds and declares that it is the right of every person, regardless of race, color, ancestry, religion, national origin, to be secure and protected from fear, intimidation, and harassment. That's statutory. The exercise of rights protected by the Constitution of the United States. Okay, so it is okay, yeah. So
May I object?
yeah, you can't object to a statute.
Relevancy.
Pardon?
Relevancy.
Relevancy? Well, I've risen.
How can you object to a statute? There's no objecting to a statute.
Sir, you can't talk over someone else. She has the right to object, then the court has to make a ruling on that, so don't talk over me. You said relevance, which I'm trying to let him tell me how this is relevant. And that's what he's doing, so then the court will have to decide if it's relevant and how much weight to give to it. I'm just trying to give him an opportunity to explain his position that an alleged violation of what he is saying is civil rights intimidation would give him grounds for an order of protection. So let me hear him out.
So her motion for relevance, or whatever she said, is declined, or what is the word? Overruled, right?
It's overruled. Please continue.
Okay, so further on in the statute it says injuries or threatens to injure or coerces another person with the intent to unlawfully intimidate another from free exercise or enjoyment of any right or privilege secured by the Constitution or laws of the state of Tennessee. Okay, she's attempting to coerce other people to deny me my constitutional rights under the state of Tennessee and the U.S. Constitution.
How so? How so? What did she do?
She tried, okay, if you want to get to that, well, okay, so in that statute, furthermore, D, it says a violation of subsection B is a Class D felony. The penalties provided in this section are, the penalties provided in this section for intimidating others from exercising civil rights do not preclude victims from seeking any other remedies, criminal or civil, which this is, otherwise available under the law. This is all under the law. A Class D felony is punishable by 2 to 12 years imprisonment and a fine of up to $5,000. That's all statutory, okay? So you're asking what she did to break those statutes, is that correct?
Yes, that's correct.
Right. So she attempted to register a foreign decree in Davidson County before a final judgment was rendered in the state of California.
Okay.
She's interfering with my right, civil right, to appeal by bifurcating, by...
From appealing, it was overruled. Judge Robinson denied the motion to register it because he found that it was not a final order. Thus, that case is still ongoing.
But she's attempting to do something that she's not allowed to do by statute.
Anyone can attempt to register a foreign decree and argue that it should be registered, and then it's up to the court to determine whether or not it should be. And I don't see any sanctions or finding by Judge Robinson after a hearing on that motion that would indicate he thought she was doing anything intentionally to.
Okay, so because he didn't specify the statute or issue sanctions, that means that all of this is not applicable?
That means that all of this is not what?
Applicable?
So far, it's not applicable. I'm finding that this is not applicable. First of all, as you correctly noted, this is a civil proceeding. It's not a criminal proceeding. So criminal offenses have nothing to do with this particular cause of action. The fact that she initiated a legal action to
Unlawfully. That's what you're missing.
Don't interrupt. Don't interrupt me. That she initiated a civil action to attempt to register a foreign divorce decree, which was denied, so it wasn't able to be done, which means you can continue with the appeal that you have pending in Orange County, California. So she didn't impede your right to.
No, she didn't successfully.
You're still. I think you're still interrupting me. So what you're saying, so that anybody can file a lawsuit. There's no finding by Judge Robinson, who heard this, that she had ill intent or malintent or had any intention of preventing you from exercising your rights, civil rights. So
Her intent is immaterial.
her intent is very material.
It can't be, not by statute. There's no mention of intent in the statute. This is all statutory.
You show me the statute. Is this what this statute's here? We're not even here for this. You've got a criminal code pulled. This is not a criminal action. With an order of protection, there has to be an intentional injury, intentional harm. Okay? That it is intentional. And it has to be physical or threat of physical or intimidation or harassment or stalking.
No, we already got past that point where it can include emotional abuse.
It can include emotional abuse if it rises to a very high threshold.
Okay, well, where is that threshold, and who determines what that threshold is? And this is risen to that threshold.
The court does. I apply that. I apply the statute to every set of facts, and I make that determination.
So it's completely arbitrary as to whether or not you think it rises to a level. Where's the definition of rising to a level?
Well, that's what happens when you go in a courtroom. You have someone presiding over it who has to be the trier of fact, and I have to apply the law.
But you just entered, yeah, but you just said something arbitrary.
I just said what?
You didn't say a fact, or you didn't say anything about the law. You just said something arbitrary.
What did I say that was arbitrary? I'm a little confused.
Rising to a level.
Yeah, that's not arbitrary. That's applying the statute for an order of protection to your set of facts. And then I determine, based upon the set of facts, applying the law to it, does that rise to a level necessary? I don't even hear the facts. All you've told me is that she filed a motion trying to enforce a decree that you said she shouldn't have been able to do. She wasn't able to do it.
No, she did do it. She did do it. She wasn't successful in proceeding forward.
She has that right. There's nothing I can do. This court can't prevent her from filing a motion asking for something to be enforced. She lost her case. She lost the motion. It was denied. Where's the harm? Where's your harm?
The harm is I had to hire an attorney to defend myself for something that I shouldn't have had to do, because she's not allowed to impede on or impede upon my civil rights to appeal. That's what's happened.
That's not a ground for the issuance of an order of protection.
It's emotional abuse.
Sir, perhaps it's not reasonable emotional abuse. Perhaps you should file a motion and ask for sanctions by Judge Robinson, who heard it. He heard it. He denied it. Perhaps you can ask him to impose sanctions of some kind. I don't know that that will be successful, but to me, that's where you would go. You would ask for sanctions. You wouldn't ask for an order of protection. An order of protection is truly for domestic violence not what you perceive to be emotional abuse because she attempted to register through a legal process a foreign decree. That
Right,
was
fraudulently. She fraudulently did that.
Okay, let me hear what she has to say.
No, I'm not done.
Well, you're done right now, because I'm telling you you're done right now. I'll let you follow up. You'll get the last word. But I want to hear what she says because you, quite frankly, your testimony is a bit confusing to me. So,
Well, just because it's confusing doesn't make it invalid.
well, it's invalid from what I've heard, and you're not making a lot of sense, and you're citing statutes that have nothing to do with why we're here, and your contention that she didn't have the right to file a motion and ask for a foreign decree to be enforced, and that you said it was fraudulently done with absolutely no proof that it was fraudulently done, is a little bit of a weak argument to me. So I want you to hold on. I want to hear from her, and then I'll let you respond again. What is your response to what Mr. Greenberg has said?
Well, my response is that this is in retaliation to current orders of protection that we have had in place for the last 5 years that are currently under review for the Orange County Court to extend the order of protection for me and the 3 children. He's obviously stating that he feels harassed because I did go through legal channels to try to register a judgment that I didn't realize was not considered final, and that he is appealing it.
It's not your turn. I'm ruling, I'm speaking.
And he's contacted me through email.
But that's not what I'm here for.
There's nothing going to happen.
I'm not, ma'am, I'm not here for any order of protection that's in effect in California, because I'm here because he filed this petition. So that's what I'm focused on. So I need your response, not to any of that other superfluous stuff that's happened, but your response to him saying that you inflicted actionable emotional abuse toward him by fraudulently filing a motion to enforce the decree. I think that's pretty much the crux of it.
I haven't been in contact with him for 5 years. I did not fraudulently file the motion to
Objection.
for foreign decree. I filed it because I was under the impression that's what I needed to do in order to fulfill this judgment from California. I did not realize I could not file it before appeal. I do not have any intention of ill will or
Objection. Her intent is not relevant. Relevancy.
Did you, overrule, did you have an attorney?
I have an attorney now.
Did you have an attorney who helped you file the motion or the petition?
Yes, I do.
And who is that attorney?
Marjorie Haynes.
Marjorie Haynes. So she represented you. She filed that motion, that
Yes.
petition to enforce the foreign judgment on your behalf.
Yes.
Okay.
Knowing that the case was on appeal, which is a violation of my civil rights and inflicted emotional abuse.
Intimidation happens to be a basis for abuse under the Family Code section 6320.
Well, I'm sorry. I'm going to tell you this right now, Mr. Greenberg. You're in the wrong forum for that relief you're seeking. That is not the intent for an order of protection.
It is. It's
So
emotional
5
abuse.
days. Do not interrupt me, sir. You have 5 days to file a notice of rehearing, and Judge Robinson can hear this, and perhaps he'll rule differently. I'm dismissing your petition, and there's no temporary order because the magistrate did not issue a temporary order based upon the allegations set forth in your petition. But I am going to dismiss your petition. You have 5 days to file a notice.
You said I was going to have the last word, and now you bifurcated that. I'm sorry?
I've changed my mind now because you are not making sense to this court, and you are not listening to me. And I don't think anything I can say to you is going. I can explain my ruling. I can explain the purpose of an order of protection, but you don't seem to be understanding it. And so I'm going to tell you right now that
Intimidation happens to be a basis for abuse under the Family Code section 6320.
you have 5 days to file a notice of rehearing. You will get an automatic rehearing in front of Judge Robinson on my ruling. And my ruling is dismissing this. And I am not going to allow you to testify further because nothing that you can say at this point is going to establish in the court's mind any ground for an order of protection in this case. So I'm dismissing it. We will send you a copy of the dismissal order, and then you can file your notice of a rehearing with the circuit court clerk's office within 5 days, and you will get a whole brand new hearing de novo in front of Judge Robinson very soon. Okay?
No, that's not okay.
Let's continue, because if he's retaliating and I have a job.
Ma'am, I just hear what's brought before me. Okay, I can't dictate who files what. If you feel like this is filed frivolously, you can also file your own motion. But he does have a right to be heard by Judge Robinson. If he doesn't like Judge Robinson's hearing, he can appeal it to the Court of Appeals. So yeah, it could hang around for a while. But you also have the option to ask for relief as well, okay? But I'm going to sign an order of dismissal. It is dismissed unless he files his notice of rehearing within the 5 days. But this order will be signed and given to each of you. I'll send you a copy. Just let me know what your options are, okay?
Thank you.
Okay. All right, we can hang up on the call.
I want to give you the opportunity before today's matter to respond to the petitioner's request.
Against me that I'm entitled to see.
Greenberg, we can't understand you and our record cannot be made. You are clearly just reading fast some document, and we cannot make a record when you do that. So you're here to give me testimony, not read a document.
Well, this is the testament. I wrote it out, so this would be... Okay, so I will read slower.
Go ahead.
So, back up. Without your unlawful invocation of the aforementioned emergency rule, this hearing would not be occurring.
Oh, sir, what you are saying is unintelligible.
Okay.
Now, I'm not going to permit you to read a document. It's not going to work. What I need you to do is to testify.
Right, I'm trying to testify. Without your unlawful invocation of the aforementioned emergency rule, this hearing would not be occurring. This is a sham and a scam. Additionally, when do you no longer have personal subject matter jurisdiction over this case? So I need the faces letter, and I need Carla's proof of hospital visitation.
The record should reflect that the parties are present before the court. They've submitted pleadings and have had a sufficient opportunity to be heard. Neither party has objected to the court's jurisdiction.
Additionally, when do you no longer have personal subject matter jurisdiction over this case?
And so on this basis, the court finds it.
I objected to it. I objected to the jurisdiction.
That the court has considered intimidation happens to be a basis for abuse under the Family Code section 6320. be a basis for abuse under the family. He admitted he subpoenaed Madeline while she was in class in high school for a legal proceeding, which obviously was embarrassing for her. And this was done while she was a minor. He admitted In addition, the respondent testified she has had no contact with the petitioner testified she has had no contact with the respondent, and yet the respondent had her served with a request for a restraining order in Tennessee. He has failed to provide this court with any evidence that the petitioner in any way was contacting him and harassing her other than the pending legal proceedings. Having the petitioner served with a restraining order at her place of work was simply an example of further intimidation and harassment. So I will now read the orders that are going to be issued. Now I'm going to unmute and allow you to ask any questions you may have.
You lose personal and subject matter jurisdiction.
I made a finding that you submitted to the jurisdiction of the court. You appeared here today, and you've responded, and you've participated. So I find you are submitted, you're subject to the jurisdiction of this court.
But I'm asking you, when does that end?
I can't answer that for you.
So do you claim to have subject matter jurisdiction?
I claim to have subject matter and personal jurisdiction in this proceeding.
Okay.
Any other questions?